CA Saili Thakkar, on behalf of Direct Tax Committee of ICAI, warmly welcome you all for today's webinar on the taxation of charitable and religious trust. We are privileged to have with us our esteemed speaker, CA Suresh K. Mehta sir, an expert in the field of taxation. I am sure today's session will be informative and beneficial for all the participants. Before we commence the technical session, it is my privilege to introduce our Vice Chairman of Direct Tax Committee of ICAI, CA Pankaj Shah sir.
Vice Chairman joined? Vice Chairman joined?
Sir, he is not available.
Okay, so don't introduce Vice Chairman.
Okay, fine.
Just
now it is my privilege to introduce our Chairman of Direct Tax Committee of ICAI, CA Chandrasekhar Chitle sir, from Pune. He is a CCM. Started his career.
No need of my introduction. It's okay. I'll just address. Thank you, Saili Thakkar from Managing Committee of Sangli Branch, Maharashtra WRC, and CA Professor Suresh Mehta ji, who is also Lion. Particularly in case of charitable institutions, parents, you would be aware that Suresh Mehta ji has got 360-degree experience of charitable institutions. It is not only taxation, not only the law relating to the charities, but also he himself is thickly involved in charity through Lions Club, through his own Charitra Pratishthan, and various other social organizations. As far as his tax expertise is concerned, no doubt he knows taxation from very depth. He has also been professor teaching tax, and charitable institutions taxation is his favorite subject. And particularly these are the days where government has become slightly uncharitable with charitable institutions. There are various confiscatory provisions. One has to apply for registration. Again, that registration is numbered for 5 years. There are number of columns in the return of income. So if you elect some different column inadvertently, then also it results into demands. So there was a great need for the profession to have some elucidation on taxation, or rather exemption for charities. And then what are the various pitfalls which are there, and what maybe steps you can take. So friends, since we have invited expert, decades he has devoted in all the aspects of charity, I'm sure that his elucidation will enlighten you. However, if you have any issues, any queries you want faculty to address, then in that case you can post them in chat box, and maybe towards the end, Saili will read those questions and ask the faculty so that those can be answered. With this, I welcome once again Suresh Mehta ji, and let the session be proceeded.
Shall we start now?
Thank you, sir.
Yeah.
Thank you, sir. Now it is my pleasure to introduce our esteemed speaker, CA Suresh Mehta sir. Suresh Mehta sir completed his primary education from Pune Adarsh Vidyalaya and Garware College of Commerce, Pune City. Passed BCom with a merit in first class in 1973. CA intermediate and final examination with All India merit in 1976-78 respectively. Passed MCom in 1975. FCA Chartered Accountant in 1978. In general, a meritorious career. Ranked first place Mulsi Taluka PSC in April 1965. Passed LLB examination at the age of 65 years, held by the Savitri Phule Pune University in April 2017. He is a partner in Messrs. Suresh K. Mehta and Company, Chartered Accountant, Pune since 1978. Ex-lecturer at Modern College of Arts, Science and Commerce, also at Garware College of Commerce since 1986 for postgraduate and degree classes up to January 2012. Though a senior citizen, continuously crossed the limit of minimum 24 hours of continuous professional education prescribed by the ICAI. He is a director and ex-chairman in Sri Lakshmi Cooperative Bank Limited, Pune, founder and president of the Charitra Pratishthan, a social organization. Director of Tulsi Bagh Nagri Sahakari Patapedi Maryadit, Pune. A president at a Lion Club of Pune Mukund Nagar from 1987-88 and again 2012-22-23. He is also a life and ordinary member of numerous professional and social organizations. He has contributed 402 articles of professional and social interest in various periodicals so far. He has delivered 385 lectures at various professional seminars and social functions so far, written several books on auditing, trust laws, consumer movements, etc. He organizes regular blood donation functions. 213 such camps have been held so far and collected 531 bags of blood. Donation per club rupees 2000 for blood camp drive. Also implemented the National Character Development Scheme since 1998-99 in schools. He conducts regular the awareness program about right to information. He has received numerous awards for his professional and social contribution. So I now request C.S. Suresh Mehta sir to take over the session.
Respected Sri Chandrasekharji Chitade, Chairman of DTC of ICI, CA Pankaj Vaishya, Vice Chairman of the DTC of ICI, today's moderator CA Saili Thakkar, also Srimati Rituji, my professional brothers and sisters. At the outset, I take this opportunity to place on record my extremely sincere and heartfelt thanks to Sri A. Chitreji and the ICI for giving me an opportunity to share my some of the thoughts on the topic of taxation of charitable and religious trust. I am also thankful to C.A. Saili Thakkar for her kind words of introduction. Friends, the topic given to me today is taxation of charitable and religious trust. So, in my topic, I will be handling both the types of trust, a religious trust as well as a charitable trust. Basic distinction between the charitable trust and the religious trust is that the beneficiaries of a charitable trust are scattered throughout the country. As against this, the beneficiaries of a religious trust are limited to a particular faith. Except this particular thin line of difference between a charitable trust and a religious trust, most of the provisions of the Income Tax Act 1961 as well as 2025 are equally applicable to both the types of trust, maybe a religious trust or maybe a charitable trust. Friends, we are aware that 1961 Act is replaced by 2025 Act. As far as new Act is concerned, the provisions relating to the charitable and religious trust are all consolidated together in one chapter called as Chapter 17B of the Income Tax Act 2025. Apart from the provisions of Chapter 17B, the newly introduced Income Tax Rules 2026 in accordance with the provisions contained in Income Tax Act 2025 are also equally applicable to the religious and charitable trust. At the inception, I would like to make one point very clear that though we are accustomed to the word trust, institution, religious trust, charitable trust, as well as far as the new act is concerned, 2025 Act is concerned, this act doesn't use the term trust or the institution, but it has introduced one common new term that is called as registered non-profit organizations. So here we are talking about a non-profit organization which is registered under the provisions of Income Tax Act 2025. Needless to explain to my colleagues who are well versed with the registration of the companies, partnership firms, and the social organization, each of these entities are registered under a separate statute. As far as charitable and religious trusts are concerned, we are aware that these entities may be registered under Section 8 of Companies Act 2013. Formerly, these trusts might have been registered under Section 25 of the Companies Act 1956. We also have the Societies Registration Act in India. Some charitable organizations, apart from the Companies Act, might be registered under the Societies Registration Act. There are special statutes, those are applicable to NGOs. For example, in Maharashtra and Gujarat, we have a special act. As far as Maharashtra is concerned, we have got Maharashtra Public Trust Act 1950, which deals with both the charitable organizations as well as the religious organizations. So, it is quite possible that an entity may be registered under the Society Registration Act, the Companies Act, or the local act like the Gujarat Public Charitable Trust Act or the Maharashtra Public Charitable Trust Act. Apart from this registration under the laws, those are governing these entities, there is a separate provision now under Section 332 of the newly introduced Income Tax 2025 to register the name non-profit organization separately and additionally under the provisions of Income Tax Act. And the non-profit organization, though separately registered under the Companies Act or under the Maharashtra Public Trust Act or under the Society Registration Act, is required to be registered separately and in addition to the statutes under the provisions of Income Tax Act 2025. Earlier in the 1961 Act, we had the provisions of registration under Section 12AB. Now this is under Section 332 of the Income Tax Act 2025. So any non-profit organization which is registered under the newly formed Income Tax Act 2025 will be called as registered non-profit organization. This is the new term that is being used for the first time in the Income Tax Act 2025. Like this RNPO, registered non-profit organization, there are so many new terms, those are used in this particular act. For example, regular income. We all are studying the provisions of Income Tax Act 1961 for a very long time, but we never come across a term called as the regular income under the provisions contained in the Income Tax Act 1961. But in relation to the registered non-profit organizations, Chapter 17B of the Income Tax Act introduces one more new term, new concept called as the regular income. When I come to the topic of application of income, I will talk on this term in a greater detail. For the purpose of throwing a light on the issue, that there are so many new terms those are used in the Income Tax Act 2025. I have made a passing reference to this particular term, RNPO as well as the regular income. One more new feature I find of especially chapter 17B is that which is exclusively applicable to the RNPO, registered non-profit organization, and the feature is that the part 7 of chapter 17B of Income Tax Act 2025 contains a special provision called as interpretation, and this is the interpretation of the various terms those are used in part 17B in relation to registered non-profit organizations. So friends, this is the brief introduction so far as the RNPO and Income Tax Act 2025 is concerned. As far as chapter 17B is concerned, there are only 24 sections those are applicable to the RNPOs. Section 332 to section 355. All the sections with reference to all the issues related to RNPO are clubbed together. In the Income Tax Act 1961, we had the provision of 1023C approval and exemption for specified educational institutions and medical institutions or the approved institutions. Separately, we had the provisions of section 11, 12, 12AB, section 13 in relation to other non-exempt trusts and institutions. Section 35, special provision for deduction under Chapter 4 of the Income Tax Act. Then we had the provision relating to deduction under Chapter 6A, Section 80G, and we also had the special provisions like anonymous donation and the accredited income scattered over all the Income Tax Act 1961. A very good feature of Chapter 17B of the Income Tax Act 2025 is that all the provisions relating to registration, income computation, commercial activities, compliances, violence, approval, and interpretation have been all clubbed together from section 332 to 355. Apart from the chapter 17B of the Act, we also have separate set only of 10 rules. Rule 181 to Rule 90. All the rules clubbed together under the Income Tax Rules 2026. Apart from these 24 sections and 10 rules, we have 11 different forms, all again clubbed together from number 104 to 114. Form number 104 to 107 deal with the registration of RNPO under the provisions of section 332 and 333 of the Income Tax Act 2025. Rules 182 to 186 with form number 108 to 111 deal with the accumulation of income and the change of purpose of accumulation of income. Very interestingly, form number 112, with which we as the professionals are directly concerned, is the form of the audit report. We are accustomed to form 10B for a very long time under the old act. Also, for a short period, form 10BB for a period of say roughly 3 years under the old act. But in place of these two forms, 10B and 10BB, now we have one common form of audit report, form number 112. And last two forms, we were filing the statement of donation in form 10BD, and the receipts were issued by the Income Tax Department in form 10BE. new form number 113 and form number 114 will be playing the role of form 10BD and 10BE respectively under the new rules. Each form from 104 to 114 is divided into number of parts. There are different rows, those are contained in all the forms, and all the forms 104 to 114 are followed by explanatory notes. Those are extremely vital and useful while filling up form 104 to 114. So friends, this is the general structure of chapter 17b, section 332 to 335, 355, rules 181 to 190 and forms 104 to 114. And with this brief introduction of the provisions relating to RNPO, now we will proceed further to important provisions of the Income Tax Act 2025 along with the rules and along with the forms. For the purpose of convenience, I will be making a discussion with reference to the serial number of various forms, and therefore I will firstly touch upon form number 104 and 105. As I have observed at the beginning, all the forms are equally applicable to religious trust as well as the charitable trust. So my entire discussion subject to special provisions contained in the Act will center around both the types of organizations, a religious organization as well as a charitable organization. Firstly, we will move on to form number 104. Function of form number 104. In order to get ourselves thoroughly acquainted with the role of form number 104, I will go back to the provisions contained in section 12AB as well as section 80G of the Income Tax Act 1961. This history will enable us to digest and appreciate the role played by the government in simplification of the rules and the provisions with reference to RNPO. Under section 12AB, we were required to make a separate application for the purpose of registration in form 10A or form 10AB depending upon the situation. Similarly, under section 1023C, we were required to make an application for approval. Section 12AB was talking about the registration of NGO. Section 1023C for the same purpose was using the term approval. So for the same job, two different terminologies were used. And again, section 80G was using the term approval of a trust under section 80G. So we were having different forms, form 10A and form 10AB separately for 1023C, 12AB and section 80G approval, 12AB registration and 1023C approval. Extremely appreciable fact about form number 104 is that whether you want a registration under section 332 or an approval under section 354, you will be having a liberty to use one single form 104. So this is the first most welcome change. in place of two separate applications for approval and registration under the old regime, under the new regime, form number 104 will be simultaneously used for both the purposes, registration as well as the approval. Registration now under the new act will be governed by section 332, and approval, formerly section 80G, will be governed by section 354. Whether you are applying for registration or for an approval. Now there is no question of section 20 separate approval under the new act, because all the NGOs have been brought under section 332 or 354 now together. Now, first feature about form number 104 we have seen is that this form is useful for approval as well as registration. One more interesting feature is that you are not required to fill up these forms separately for registration and approval. You are having a choice whether you want to make an application for registration, then you have to choose the registration window. If you want to apply for approval, you have to choose the approval window, and if you want to choose both, then in place of taking separately registration and approval, you can take jointly both together in the third option, both for registration and approval. So friend, this is the most welcome change introduced by Government of India so far as the Income Tax Department is concerned, so far as the chartered accountants are concerned, and so far as the NGOs are concerned, the RNPOs are concerned. Second, the opening part of this form number 104 will be mostly pre-filled. 104 first 5 rows. Friend, I will be making a reference to the form, to the row number in the form, and also to the note that is at the end of the form. So form we have to understand with two issues separately. The row number which is directly a part of the form, and a note which is at the end of the form given in support of various rows. Form number 104 has got two parts, part A as well as part B. Part A has got 5 rows. These 5 rows are very simple, and in most of the forms, form number 104 to 111, you will find in most of the forms, these first 5 rows are common. What are the contents of these 5 rows? Name of the applicant trust, PAN of the applicant trust, address, email, and mobile. These are the 5 particulars those are required to be given in first 5 rows of the form. However, there are certain explanatory notes, those are given at the end of the form. Wherever this information is there is an explanatory note, normally note number 1 and normally note number 2 at the end of these forms, wherever the issue of name and address is there. There is one more interesting note for the purpose of simplification, that some of the information will be pre-filled. Take the case of name, address, and PAN of the applicant RNPO. What are we doing? We are uploading this form on the account of the portal of the applicant RNPO in the portal of the Income Tax Department. So whenever you open your own account on the portal and you open a particular form, it is our experience that your name and PAN automatically appear. We are also accustomed to our address, to our static data like mobile and the email address on the screen. It is written in note number 1, 2 and also the final note that some of these informations will be pre-filled. As far as address is concerned, note number 2 in most of the forms is very interesting. The logic of writing an address which is taught to us in business correspondence subject is strictly followed in the note number 2 so far as address is concerned. I appreciate the logic followed by the CVDT while structuring the address of the taxpayer. They have followed the formula special to general while giving the address, and then they specify the subheads. Firstly, say the flat number which is very unique to your flat. Then floor number 1, 2, 3, 4. Then building name. Then society name. Then your area. Then the city, town or the village. Then the district. Then the state. Then the country. And finally the PIN code. So I was highly impressed by the way in which the address field of the applicant RNPO is filled up, is required to be filled up by us. This is so far as the address field is concerned. Now, so far as email, PAN, mobile, there is nothing special to be discussed. Now again we will go to form number 104 other parts. One interesting feature and basic feature of form number 104 is that this form has got a very limited applicability. What do I mean by the term limited applicability? The rule says that this form will be used only when the activities of the applicant NPO have not commenced. If your activities have already commenced, regardless of the fact whether you had the registration and approval or not, you are to compulsorily going for form number 105. So friends, this is the first fundamental difference between form number 104 and 105. Friend, when I will be talking with reference to a particular provision, I will have to travel through other provisions of the Act also, of this Act, these rules or the old Act, old rules, for the purpose of explaining the current state of affairs of the forms or the rules of the section. We never had the issue of commencement of activities in the old regime, Form 10A or 10AB. The period of registration was dependent, but form we didn't have that choice. But here, so far as form number 104 is concerned, it needs to be kept in mind that 104 will be used only if the activities have not commenced. Second rejoinder is that there should be no earlier regular or provisional registration or approval under the Act. So, if your activities have not commenced and you had no earlier registration on approval, then only the doors of 104 are open to you. Otherwise, you will have to go compulsorily for form number 105. In view of this fundamental difference, conceptual difference between form number 104 and 105, the structure or the contents do differ considerably between form number 104 and 105. Before I proceed further, on 104, I would like to invite your attention to one important issue: what is meant by commencement of activities. Though Part 7 of Chapter 17B of the Act talks of interpretation, there is no definition or the explanation of the term given in commencement of activities. Neither in Section 2 of the 2025 Act you find the definition of the term what is meant by commencement of activities. Just for the purpose of additional information, I would like to share that one term value is used at many places in Chapter 17B with reference to RNPO. This term value, to my mind, was not defined in the Income Tax Act 1961, but interpretation part of 17B in relation to RNPO do define or do interpret what is meant by the term value. So, the point I want to drive at home is that the term commencement of activities is not defined in the Act, and therefore I think it fit to discuss this term in a greater detail. The reason is that if activities have not commenced, then only 104 is available, otherwise you have to go in for 105. And if there is delay in application, you are likely to face some consequences, and therefore I believe in the principle earlier the better, and therefore I would like to talk in a greater detail on what is meant by the term commencement of activities. Deliberately, I will take the case of an educational institution. Accidentally, in the month of June, all the schools are commencing. First term academic year is starting in June 2026. I will assume for a moment that there is a school which has opened first standard for the first time this year in the academic year 2026-2027. Teaching has started in June 26. I feel teaching is not a part of commencement of activity. Friends, you are aware that for the purpose of commencement of a school, you are required to take a lot of steps, legal steps as well as the other practical steps. As far as legal steps are concerned, firstly, you are required to take an approval from, I'm talking about Maharashtra, from the government of Maharashtra. If you are going to start a college, you are also required to take an approval from the University Grants Commission. And for the purpose of obtaining a registration, maybe from government of Maharashtra or maybe from UGC, it takes months together, maybe even an year together. In my considered opinion, you are taking a step of making an application to the government of Maharashtra or to the UGC is a part of commencement of activity. Along with making an application to government of Maharashtra and to the University Grants Commission, what the management does is that it goes after preparation for the infrastructure, the school building, the playground, the science laboratory, the computer laboratory, the regular library, the computers, the furniture, the recruitment of teaching, non-teaching staff, security staff, etc. And this is not just possible within a period of 1 or 2 months. That also takes a very long time, maybe even 2 to 3 years. Visualized from this point of view, after incorporation of your society as an educational institution, in my considered opinion, the moment you make an application to the appropriate authority like UGC or the Education Department of Government of Maharashtra or the CBSE, in my opinion, your activities are starting. And therefore, in my opinion, mere commencement of academic courses is not the commencement of activity, but the very first step, infrastructure preparation and the application for approval are all parts of the commencement of activities. Having spoken in detail on the concept of commencement of activity, the role of form number 104 and first 5 rows of 105, now I will proceed further to next part of form number 104, row number 6, which I have already referred to, whether you are applying for registration or applying for approval or you are applying for both. One more interesting part of the form 104 is very sensitive issue, irrevocability clause. In my considered opinion, this issue is not at all applicable to the entities those are registered under the Societies Registration Act, the Companies Act, or the local acts like Maharashtra Public Trust Act or the Gujarat Public Trust Act. What form number 104 requires is that you are to state whether in your form, in your trust deed, there is a provision regarding irrevocability of your non-profit organization. And if there is no explicit direct clause in connection with irrevocability, you will not be eligible to get either the registration or the approval. And this will close all your doors for concessional tax treatment under Chapter 17B. And therefore, like commencement of activities, I will talk in a greater detail on revocability as well as irrevocability. The moment my entity is registered, either under the Societies Registration Act which is the Central Act, or under the Companies Act, which again is a Central Act, or under the Maharashtra Public Trust Act or the Gujarat State Public Trust Act. This registration closes down all the doors of revocation of the trust by the author, founder, or settler of the trust. What is meant by revocation? Revocation is nothing but, in practical sense, shutting down the non-profit organization. Neither the Companies Act, nor the Public Trust Act, nor the Societies Registration Act confers any such power either on the founder, settler, author, managing committee, governing body, or for that matter, general meeting, or maybe the extraordinary general meeting, and maybe the special resolution to revocate a trust. All the powers of revocation, which implies the dissolution of a trust, are vested under the Companies Act in the Register of Companies and under Maharashtra Public Trust Act under the Charity Commissioner. As far as the Charity Commissioner of Maharashtra is concerned, I would like to add one more interesting point. There is no separate authority appointed in Maharashtra state to administer the provisions of the Societies Registration Act. If an entity is registered under the Societies Registration Act and is having affairs in Maharashtra state, all these powers are vested in the Charity Commissioner appointed under the Bombay Public Trust Act, Maharashtra Public Trust Act. So in Maharashtra, even if Charity Commissioner is there, the Societies Registration Act doesn't give any authority, as I said, even under a special resolution of the extraordinary meeting to the members of the trust to dissolve the trust and distribute the assets. Moreover, the provisions of the Income Tax Act also prescribe that once a trust is registered or approved, in a very exceptional case of dissolution, the assets cannot be distributed at the sweet will of the trustees, but those are required to be compulsorily distributed among the registered non-profit organizations. So in view of all these provisions, I am of the considered view that there is no necessity of having a clause of revocation so far as the form number 104 is concerned. Friend, while I am talking to you, I will be talking more on practice, less on theory and less on legal cases. Still, in the context of revocability, I would like to invite your attention to one very important, very interesting judgment recently delivered by Mumbai High Court in a writ petition filed by Bombay Chartered Accountants Society and other social organizations and professional organizations. And Bombay High Court has ruled in favor of the applicant, stating that revocability provisions are not applicable to the entities, those are incorporated under the various provisions. Unfortunately, it is learned that CBTT is thinking to challenge this verdict before the Supreme Court of India, which will be the final place of decision so far as the revocability is concerned. So friends, this is what I wanted to clarify so far as row 8 contained in form number 4 with reference to revocability is concerned. Just for the purpose of academic information, row 9 of form number 104 asks you the question whether any application for registration for approval was rejected earlier in the past. I have already clarified that 104 is applicable when earlier there was no registration or approval and the activities have not commenced. So this row is just an additional information so far as the applicant trust is concerned. Row number 10 of form number 104 seeks to know from you the expenditure for religious purposes incurred by the non-profit organization. Like revocability, I would like to talk on this also in a greater detail. Like commencement of activity and revocability, this term is neither defined in section 2 nor in section 355 part 7 of 17B of Income Tax Act 2025. However, as a practicing chartered accountant, in my considered opinion, we must give a thorough thought to the classification made by the non-profit organization so far as religious expenditure and non-religious expenditure is concerned. Apparently, an expenditure may look like a religious expenditure, but strictly it may fall within one of the 7 limbs of the definition of charitable purpose given in new section 223 of Income Tax Act 2025. I will give an example. Very recently, I was addressing one study circle in Pune on this topic, and the issue came regarding the Goshalas. The moment we utter the word Goshala, we have an impression that this is a religious activity. Friends, this is the faith that the trustees have got. That Goshala is a charitable purpose because they have that faith. As a practicing chartered accountant, we have to think of whether this Goshala can be fitted anywhere in one of the 7 limbs of 223, New Act 2025. This query was raised to be by one of the participants in the audience. Goshala is charitable or not? I invited his attention to one of the limbs of 2 subsection 23, protection of environment. You are talking of protection of air, water, land. Why don't you talk protection of animals? Protection of animals is very much a part of protection of the environment. All the birds, animals, human beings are very much inseparable part of the environment. And then if you are taking proper care of specified animals, you can take a stand that this is not my religious expenditure, but this is my part of section 223 charitable purpose protection of environment. And ITO and initially the CIT exemption will find it extremely difficult to refuse your stand. Though you might have got a very strong sentiment of religion in your mind when you run the Goshala. And I added one more statement in the audience. You add some buffaloes also there because you have the necessity of future generation, future nurturing of the cows. For that purpose, you need some breeding. And if you have this type of combination of various types of animals, it will be extremely impossible for the CIT exemption who is examining your 104 as well as 105 to put this particular activity of Goshala under the head religious expenditure, and you can strongly convince that this is not religious but this is very purely section 223. One more interesting issue I will tell you, because our skill is on twisting of the facts in a constructive and positive manner. Now, so far as Maharashtra is concerned, probably that may be there in other parts of the country, I don't know. But in Maharashtra, we are celebrating one religious month called as Adhik Jyesht month. In this month, we carry out various religious activities. And we have, at one place, we have organized a lecture, spiritual lecture, on the preachings of Lord Yogeshwar Sri Krishna. I gave this example also in the audience. The caption of our talk was Yogeshwar Sri Krishna as the management guru, and this series was continued for 3 days. The moment you twist your heading as management guru, that goes to everyone in India, 140 million Indians, not related to particular religion, not related to particular faith, and it goes to peace and unity at the national as well as the international level. Friends, this is the deliberate attempt I have made to talk on religious expenditure. Our skill, as I told you, is to convince. And finally, if we are unable to convince, we should confuse. Unless and until he gives a negative decision on your application 104, 105. Next part is the nature of applicant. What is the nature of applicant? Here, a very time-taking discussion will have to be made, but in view of paucity of the time, I will restrict my scope only to first limb of this particular issue, nature of the applicant. Section 332, subsection 1 divides the applicants into 8 different categories. These different categories are further classified, and there are more than 24-25 subcategories of the nature of the applicant. What are the different natures of the applicant given? A public charitable trust, like registered under the Maharashtra Public Trust Act or the Gujarat Public Trust Act. A society, not a cooperative society, but a society registered under the Society Registration Act. Section 8 or Section 25 company registered under the Companies Act. University or an educational institution affiliated to the university, not other educational institutions. Entities, those are financed by the government. Certain entities like Investor Protection Fund, certain entities which are specifically notified by the Central Board of Direct Taxes, and the entities like the funds, those are established by the army personnel. This nature of applicant, I have given a very detailed note about further subclassification of nature of applicant in my note. In view of the paucity of time, I am intentionally omitting that particular detailed discussion. That table given in note on form number 105 is a self-explanatory, and to my mind, it will leave no doubt so far as further classification of nature of entity is concerned. Then row 12, nature of activity. Again going back to religious and charitable. Charitable activities are activities covered by section 2, subsection 223 of the new act. Religious expenditure, I have already spoken to you. You are to define, though in accounting I have categorized as a particular expenditure as religious. From taxation point of view, that expenditure may be a charitable, and it is quite possible that I may be engaged in both the activities simultaneously, religious as well as charitable. This is so far as the nature of activities and nature of applicant is concerned. Two issues are required to be understood separately. Firstly, the nature of applicant itself. 8 classes I have given at the beginning, that is like a trust, society, company, notified entity, etc. As again, those 8 classes, those are there in the nature of entity. There are only 3 classes so far as nature of activity is concerned: religious, charitable, or both. Next interesting part, row number 13 and 14, talk about the formation of the entity. There is one clarification given in note number 8, which is at the end of form number 104, and this note states that formation will cover 3 things at a time: registration, incorporation, and the creation. So formation term used in a very wide manner, and that may include the entities like, as I already observed, a company, a society, or a public charitable trust. As far as the formation is concerned, you are required to give the details like the date of formation, the registration number, and the authority granting the registration. Again, the term registration number, with which we are concerned, thoroughly acquainted in day-to-day practice. One more new term is used in rule 104, as well as all the rules 104 to 180 to 181, 81 to 90, unique registration number. And unique registration number is nothing but the registration number given to you of the under the statute governing you. Next part talks to you about the objects of the trust, whether your objects are charitable or religious or both. On objects clause, especially the section 223, I will intentionally deliberate in a greater detail. Take the case of one educational institution in Pune called as Maharashtra Education Society. It is established with the noble object of education. So it is covered very much in 223. The provisions contained in chapter 17b put a lot of restrictions on achieving the objects which are not specified in your objects clause, even if they are very much charitable in nature. Suppose our Maharashtra Education Society, which is set up for educational purposes, carries out some activity which is of a medical nature. CIT exemption in an exceptional case may take a stand that though medical is very much a part of 223, it is not a part of your objects clause. So friends, I am highlighting here a distinction between 223 and objects clause of your organization. Even if your objects are very much charitable, strictly as per 223, I will strongly recommend it to ensure that even if, say for example, your organization is primarily an educational organization, you add one more clause to your object clause that all these 7 objects given in present 223 section of Income Tax Act 2025 or any other statutory modification thereof as a part of our object. So this will open all the doors of all the activities for your organization, and refusal of registration and approval or taking an adverse action against you for carrying out those objects which are not in your objects clause, though very much charitable, will not be there. If there is no such provision in your objects clause, I will strongly recommend you to get your objects clause amended by adding one simple clause there to Section 223 of Income Tax Act 225 or any other statutory modification thereof. Deliberately, I am adding the word statutory modification thereof. For example, we had earlier the trust deed where reference is made only to the Income Tax Act 1961. Though Income Tax Act 1961 225 says that action under 1961 will continue, but the trust deed says only the activity is allowed under 215 of Charitable Purpose 1961 Act. This will give a little room for tussle for the CIT exemption to grant you approval. So, as a measure of abundant precaution, it will be in our interest to add a clause, Section 2, subsection 23 of Income Tax Act 2025 or any other statutory modification thereof as a part of object clause of your NPO. This is so far as the formation and your object clause is concerned. This object clause has got very much relationship with your formation, because your formation, there is one document called as the trust deed or the memorandum of association and the articles of association. One more interesting information is sought from you in form number 104, that is recognition. And here again, like formation, the term recognition is used as per the note given at the end of 104 in a very broader sense. And the note at the end of 104 says recognition includes the registration under any act 61 or 225, 2025, approval under both the acts, old new, and a notification. Friends, we know, apart from the registration granted to the NPO or the approval granted to the NPO, Central Board of Direct Taxes is vested with a power to notify an entity under either Section 332 or Section 354, under Old Act Section 80G or Section 12AB or even 1023C. So here the recognition covers all the three issues. Your registration under Income Tax Act, approval under Income Tax Act, and also the notification issued by the CBDT in your case. As far as these notifications are concerned, these are the self-explanatory details, and you have to just give the details, the authority issuing the registration, notification, or the approval, and the relevant order number and the date. Apart from this registration under the Income Tax Act, you are also required to give the details of registration under other acts. Firstly, the registration under Income Tax Act was considered registration, approval, and the notification. And now the next row asks you details about your registration under the other acts. There are only 4 options given to you so far as your registration under other acts are concerned. 3 acts are specifically referred to, and 4th you are required to add. First 3 are Foreign Contribution Regulation Act 2010, the SEBI Act 1992, registration of NPO on the Darpan portal of Niti Aayog. These are the 3 specific registrations. Those are sought by 104 in this row. And the last option is under any other act. Simple example we will take. Very small NPO. Normally, this NPO is registered. I am talking about Maharashtra state, where the Professional Tax Act is in force. These entities are registered under the Provident Professional Tax Act also. It is quite possible these entities are registered under the Provident Fund Act also, if there is no grant given by the government for their salaries, and their salaries are paid by the management from its own income. So these are the acts like Provident Fund Act, the Professional Tax Act, under which the NPO might have been registered. Quite interestingly, in respect of educational institutions, where your educational course is not approved, say Tally course conducted by a commerce college, which is not a part of your approved syllabus. If it is not a approved syllabus, but your academic activity, this will attract the provisions of GST. So, even if your activity is charitable, very much covered by 223, as I observed earlier, your NPO might have been registered under the Profession Tax Act, Provident Fund Act, GST Act, or so many other acts. If there is registration under such acts, you are required to give the details of such acts, and the details sort are registration number, date, and the authority granting you the registration. Next issue regarding office bearers. I have given a very exhaustive note on the topic of office bearers. So I will highlight only the important issues so far as the office bearers are concerned. You are required to give the details of office bearers. The question is, the date in the light of which the details are required to be given on the date of application or on the date of my balance sheet or on some other date. This row we deals with office bearers specifically say that these details are required to be given on the date of application. Why this date of application in the light of which the details of office bearers are required to be given is important? I will explain you the simple practical case. Mr. X was the chairman of a NPO on 1st April 2025. His tenure came to an end because of the provision contained in its article on say 30th of April 25. Further, I am assuming that it has made an application for renewal of its registration approval on 1st September 2025. Now, at the beginning of year, Mr. X was the chairman of the trust. On the date of application, Mr. Y is the chairman of the trust. Question is, whose name should I write as the office bearer? Rightly observed in the note under this row, the details of the office bearers on the date of application are required to be given. The details are very simple: name, address, and that other information, PAN, email, mobile, etc. It is quite possible that these office bearers are falling in one of the 20 categories. Those are given in the note at the end of this row. Different 20 categories are given. What are the different categories? Author, founder, a person who has made a substantial contribution, then a settler, member of the managing committee, trustee, and so on. You are required to members of the general body. These different 20 categories of office bearers are given. Surprisingly, it includes the members of the general body also. To my mind, only the details of the members of the governing body or the managing committee or the board of trustees on the date of application are required to be given. One more interesting information is required to be given with reference to the office bearers, and that is he is a identification code. There are only 4 codes given with reference to identity of the office bearer. Most popular is the PAN. In an exceptional case, a person may not be holding the PAN. In this case, I would like to invite your attention, which I was to discuss at the beginning only, but in course of discussion, I forgot to discuss. Connected with PAN, the address of the non-profit organization. In the address particulars, last part is the PIN, postal identification number. Friend, we know that in other forms where the address issue is there, with reference to non-resident Indians, they are asking the question for zip code. I will now talk on zip code, which I was to talk on at the time of address. Address code doesn't ask you the zip code. There is some logic there is some legal provision behind that. In respect of the applicant, the RMPO, the NPO, zip code is not asked. The reason is that Section 332 of the Income Tax Act 2025 say, for the purpose of eligibility to be registered under Section 332, the applicant must have been registered only in India. If your entity is registered outside India, you are not at all eligible to be registered under the provisions of Section 332. And that is why intentionally in the address of the applicant NPO, there is no space left for mentioning the JIP, which is there in other cases, including the address of the office bearers. And in case of office bearers, further they say, if you don't have the PAN, you can quote the passport number or the tax identification number of the country where the office bearer is residing. This clearly implies that though the trust is registered in India, the trustee may be residing out of India. So identification, either PAN card or passport or election commission identification card or the tax identification number of the country where you are residing. This is so far as the office bearers are concerned. Further, they are asking the details about the return. They are asking only the information whether you have furnished the return of income or not. If you say yes or no, they are not asking the further question, quote your acknowledgement number and date. If your answer is no, it goes directly to the next row. However, one note that is referring to the enclosure states that if there are no enclosures, there are no return filed by you, you are to furnish the accounts maximum for a period of 3 years. So, if return is not furnished, in the light of the list of enclosures, which is given at the end of this form, makes it mandatory on your part to give the details of the audited accounts of your trust for last 3 years. After submitting these details, last part of the form is the enclosures. Enclosures are very interesting. Trust deed or the memorandum of association. It is quite possible that in place of forming a trust under a specific act, it might have been brought into existence because of some other instrument under the Indian Trust Act. For example, a person has made a will, and in a will he has stated that after my death, this property will be vested in a particular trust to be formed under the Indian Trust Act. Then the will, because of which this trust is brought into operation, a copy of that will is required to be attached to this particular document. Then the registration certificate may be issued by ROC or by the registrar of societies or by the charity commissioner. Copy of the certificate of registration under Foreign Contribution Regulation Act. Your copy of the rejection, maybe approval or the registration under the tax laws. your audited accounts for maximum 3 years. So far as these various documents are concerned, note at the end of this form says that this form, all these documents needed to be self-attested. However, in respect of the next document, it doesn't talk of the term self-attested. It only says proposed activities. This is in the light of the activities, those are required to be proposed by the NPO. This is the brief summary of the forms, those are required to be given. All these rows are followed by an undertaking. Each and every part given in the undertaking is required to be read with greater caution and care, because each part of the undertaking is requiring you to shoulder a large number of responsibilities regarding compliance or breach of the Income Tax Act, either 61 or 2025. Firstly, the undertaking says that I have the authority to furnish this form. So, I will strongly recommend you that though you are not a signatory as a CA to this form, in practice, on behalf of the NPO, as a CA, we will be furnishing the form practically on our PC, where our IP address will go to the CIT exemption. You obtain a resolution from the managing committee or the board of trustees authorizing a particular trustee to furnish form number 104 on the portal of the income tax department. Because anything done without an authority is void ab initio, and your application will be not at all to be forced. Second, you are required to give an undertaking that the information given is true and correct. I don't know why the word complete is missing. Section 353 about accredited income provides that if any information is given wrongly, the NPO will be liable to the provisions of accredited income. And therefore, in the context of that provision, you have to ensure that the information given by you is not only true and correct, but is also complete. First, next undertaking you are giving that if there are any changes, those have taken place in the information given in the form number 104, that will be intimated to the CIT exemption. I will cite one practical case. Mr. X has signed the application 104, and after 15 days, because of some reason, he resigns and Mr. Z is taking his place. Still, your application is not disposed of. You have the statutory responsibility to inform the CBDT that there is a change in the signatory. And interestingly, you are to give an undertaking that your activities have not at all commenced, because 104 is applicable only if activities have not commenced, and next it is followed by your signature, place and date. Friends, you are aware this form is required to be submitted on the portal, maybe under the DSC of the applicant or through EVC. Interesting part of 104, so far as duty of the income tax department is concerned. CPC or the CIT exemption have no authority to call from you, from the applicant, any document. He has no authority to call for any information from you. This is because your undertaking is giving all the information and he has no right to carry out to make any inquiry. So no document, no information, no inquiry. What is the result? Within a period of 1 month, CPC or CIT exemption is duty bound to give you a provisional registration for a period of 3 years. So with this, your form number 104 will come to an end. I have deliberately discussed 104 because this is the starting point of taxation, maybe of the religious trust or of the charitable trust. As far as 105 is concerned, now concluding 104, while going to 105, I will like to add that I will be adding only the new points. Those are there in 105. 105 contains large number of the rows which are already covered by 104. The contents of 105 are just like 104. Due to the paucity of the time and in view of avoiding the repetition, I will now talk on 105 in the light of those rows only which are new only for 105. Before I speak on number of rows, those are there in row number 105. I would like to highlight upon one important feature of 105. And the important feature of the 105 is that even if there is no prior approval or registration, but if your activities have commenced and you don't have either the prior registration or prior approval and you have commenced your activities, your doors of 104 are closed and only door open to you is of 105 because your activities have commenced. Mere commencement of activities doesn't mean that you are holding the registration or approval. So it is quite possible that in this form 105, like 104, you may have both the courses of action, provisional registration for your income exemption, provisional approval for donors, regular registration and a regular approval. All these different options are available to you under 105. In an exceptional case where your trust has undertaken some modifications, then or due to some reason your NPO has become inoperative, then also you are required to make an application in 105 only. So 104 and 105, this is the basic difference. 105, every case of commencement of activity, including inoperative trust, modification in your objects which were not in accordance with the earlier registration and approval, provisional registration, provisional approval, or renewal of regular registration and renewal of registration of approval. This is so far as the form number 105 is concerned. 105 asks you one more interesting information about your application itself. The background in the light of which you have made an application. This is a very interesting part. And there are 4 classes of your application itself. One, the reapplication. Second, application made with delay, but delay condoned. Application made with delay, but delay not condoned. Delay is in process, and reapplication. So 3 positions so far as delay is concerned, and 1 position reapplication is concerned. What is meant by reapplication? It is quite possible that your form 105, not 104. Your 104, not 104, your 105 was rejected. If your 105 application for registration or approval is rejected, you are given an order in 100 and form number 107. So far as 105 is concerned, CIT exemption order is issued in form number 107. So far as 104 is concerned, CPC order is issued in form number 106. There is a difference between 104. 4 is connected with 106, 5 is connected with 107. It is quite possible that you may make a reapplication within a period of 30 days after you receive an order in form number 107 with reference to the application you have made in form number 105. Now, why will you make reapplication? It is quite possible that there was some notice of hearing issued by the CIT exemption and you could not attend the hearing electronically, or some information could not be furnished by you, though was sought by the CIT exemption. In respect of these situations, you can reapply in 105 after your 107 order is issued. So this is the case of reapplication. So far as delay is concerned, delay condoned, delay awaited, and application made in time without delay. This is the information you are required to give in this form number 105 so far as delay is concerned. Next part, section code. Very exhaustive information. Friends, I told you that now all the information is on the portal. This is really a trapping of the data. Because this data is available on the portal, you are likely to face a lot of challenges. If there is some discrepancy between the data available on the portal and the application, the data given in form 104 and 105. So you have to give a very minute attention to the next information, section code in the light of which you have made an application. You are making an application under 2 different sections, 332 and 354. Under these 2 sections, there are multiple options given to you. 4 cases I have explained to you. Without delay, that is in time, delay condoned, delay yet to be condoned, delay awaited, and firstly, reapplication. These are the 4 options. I will invite your attention to table given under section 332, and there are 7 different options those are given. application for inoperative trust, provisional registration, regular registration, then renewal of regular registration, regular approval, etc. So those are 7 different items in that table number 7, and these 4 situations: reapplication, delayed application, application in time, delay, applied but not yet condoned. Different 28 sections are given. I have given a very exhaustive code list of all these section codes in my note. And even as I repeatedly told you, because of paucity of time, I will not talk to you about these section codes. Next item is regarding the period for which the registration or the approval is required. Friends, we all are aware there is no question of approval. Approval is granted uniformly for all the trusts for 5 years under section 354 like ATG under old act. Under section 12AB, we had the provision that in some cases, small trust, we were given the registration for 10 years. Similar position is continued in new act. It says that the total income of the trust, and the next part is very important, without giving effect to the provisions of this act. That is, without talking of 85%, without talking of 15%, and without talking of application. If roughly saying, if your gross income before 15% standard application, 85% regular application compulsory to be made, your income is up to 5 crores, then you will be given a regular registration for 10 years. However, this is subject to one more rider. When should be the total income of 5 years there? For 2 years. This income limit is for 5 crore without considering the application and accumulation, and that is for 2 years. One more explanatory clause is there in the rule itself. In the year before the year of application, suppose I have applied in the year 26-27, then for the year tax year 24-25, for the tax year 25, both the years, not one of the two, consecutively both the years 24-25, 25-26, my total income without giving the effect to the provisions of chapter 17b should be below 5 crores, so that I will get a registration for a period of 10 years. This information is sought probably to verify whether my application is for the correct period or not. Other parts of the form are which are already covered by 104. I will not be talking about. Directly I will go to row number 22 of form number 105. Very interesting information. Information about the institutes, those are run by you. I will invite your attention to the name of our institute to clarify the concept of institute. Name of our institute is the Institute of Chartered Accountants of India. My question is, whether should I give the details of ICI if the ICI is applicant? My answer is point blank no, because my details are already furnished at row number 1, 2, 3, 4, 5. applicant. Then the question is, what is meant by the term institute that is used in row number 22? Simple definition, though not given, is the unit or the branch run by the applicant. Going back to the Maharashtra Education Society in Pune, it has got large number of primary schools, secondary schools, junior colleges, senior colleges, post-graduation classes, hostels, and so on. It is also conducting non-approved academic courses. So, all these units information is required to be furnished in this case. In case of an entity, though not applicable to the nationalized banks because they are not covered by NPO, if they are required to give this information, they will have to give the information about all the branches, maybe 1,000, maybe 700, like Maharashtra Bank of Maharashtra, more than 1,000 branches. If Bank of Maharashtra is applying as NPO, it will have to give the information of all its branches under the head NPO. And what are the informations required to be given? Nature of the NPO, category of the activity, address, and the person in charge. This information is required to be given very, very carefully. Nature of the activity, whether it is a school, college, hospital, yoga center, or any other entity. This is the nature of a activity. Now, category of the activity. Firstly, we saw the nature of activity. Now, school, naturally, it will fall in charitable. So, you are to say charitable or the religious. Now, for example, it is quite possible that there is one temple in a hospital. So, it will have to say a temple, and then it will have to say, depending upon the facts, charitable or religious. Address. Coming back to Bank of Maharashtra, if you are having 1,000 branches, you will have to give the address of all 1,000 branches. This has got direct relationship to your form number 112 audit report, where the place of books of accounts is required to be maintained, and you will invite one more issue, whether you are informed the jurisdictional AO regarding the place at which the books of accounts are maintained. So, friend, I have observed at the beginning that this is a trapping, and you will have to be very careful while giving this information, that all this information is already available on the portal of the Income Tax Department in compliance. Department asks you one more question, whether it is managed, administered, controlled, or owned by you. Owned by you is understandable, but I cannot find a case where it is managed by you but owned by somebody else. In an exceptional case, it may be so, but in practice, I have not found any such case about NPO where it is of managing the office of some other NPO. Person in charge, and his details are required to be given. His name, email, mobile, etc. This is so far as the nature of your institutes are concerned. They are asking you the report about the activities. This note on institutes will be of considerable use so far as your nature of activities are concerned. Next issue, they are asking about the details of your bank accounts, maybe the banks with your banking companies or the cooperative banks. Form doesn't talk about the type of the account, but as far as the object of information is concerned, in my opinion, only the details of the operating account like savings and current account need to be given. Details of the fixed deposit are not required to be given. Name of the bank, its IFSC and your account number, those are required to be given. These details are required to be given on the date of application. I would advise you that while giving the details of these bank accounts, you reconcile these details with the details of the institutes you are given in the earlier row. Friends, our time is coming to an end. We have got very few information points to be discussed. I will wind up very shortly within 5 minutes. Details regarding lands or buildings or both. Very treacherous information is required to be given. Details of all lands or buildings or both. Doesn't talk leasehold or freehold. So you have to give the details of both the lands, leasehold and freehold. Question is, why do they want this information about our land and building? Answer is very simple. They are inviting your attention to section 353, accredited income. If you are having land and building and you are liable to section 353, the valuation is done at the market rate of the land and building. That is why this information is required to be given. Information required to be given is the address, size, date of acquisition, stamp duty value, mode of acquisition, and the date of acquisition. This is so far as the size is concerned. Only the details of land and building are required to be given. Details of other fixed assets are not required to be given. Then details of commercial activities. I will only highlight what is the example of the commercial activities in the light of general public utility. In an exceptional case, I am saying exceptional case, the non-profit organization may conduct a transport facility for the general public. These I am just taking an imaginary example. So this is a commercial activity of the general public utility. The object of seeking this information is that the income from your general public utility commercial activity should not exceed more than 20%. Then next two rows, they are asking your information about your income tax return and your details about your total income, religious expenditure. Those details I have already thoroughly discussed with. Then there are no much other information required to be given. As long as balance sheet is concerned, though balance sheet details are required to be given, the presentation mode they have already changed, and then it is coming to an end. They are asking the details about the religious expenditure also. Those details are at the end of the form. I have already spoken to you about the religious expenditure in greater detail. List of enclosure to be given at the end of this form is very exhaustive and very long. That like form 104 that I have already discussed, this 105. Different time limits are prescribed for this form, ranging from 30 days to 6 months before the end of the accounting, the tax year for which the application is required to be made. As far as the undertaking is concerned, again, like 104, one has got to be very cautious so far as the undertaking is concerned. Then CIT exemption has got a right to call for the details or the information or conduct the inquiry, and depending upon the results, he may grant you the registration or approval, or he may refuse to give you the registration or approval. It is quite possible that in one case, exceptionally, he will give you the registration and approval will be rejected. In another case, registration is given, not given, approval is given. In another case, both are given. In last case, both are refused. These are the different permutations and combinations. For this purpose, you are required to read form number 107. So far as my experience with renewal of registration and approval is concerned, I find that the period for which our NPOs were eligible for registration and approval differed from the approval or the registration as given in the approval orders. So my advice to you will be, so far as the order in form number 7 is concerned, you thoroughly check the period for which you have got the registration. Approval, there is no question, approval is only for 5 years. Friend, this was the discussion I wanted to make. So far as the registration and approval is concerned, these have got direct connections with computation of your income. I have also furnished a detailed note on accumulation of income. Maybe option to be exercised in form number 108 or accumulation in form number 109. Form number 108 and 9 are followed by form number 110 and 11, which is regarding change of the purpose of accumulation and order by the AO so far as change of purpose of accumulation is concerned. And then finally 3 forms, 112 audit report. An exhaustive discussion is required, not less than 3 hours. We cannot talk on 112 in 2 hours. And then only small 2 forms, 10 BD and 10 B under the old regime, 113 and 114 in the new regime. These forms are self-explanatory and require no explanation. Only 112 needs a detailed explanation, which also talks of a computation of your income and submission of the audit report. Friends, with this, I take this opportunity again to the chairman of DTC, our vice chairman of the DTC, my moderator, CA Shaili Thakkar, coordinator Rituji, and all my professional brothers and sisters. Jai Hind, Jai Maharashtra, Jai Sri Krishna. If you have got any queries, I will be happy to answer. Thank you very much.
Sir, as in charge of the Direct Tax Committee, on behalf of the committee, I would like to express my sincere thanks and heartfelt gratitude for enlightening us on this topic of taxation of charitable and religious trusts. It has been a really enriching experience, and we thank you for that, sir.
Most welcome.
Thank you, sir.
Shall we wind up?
Thank you, ma'am. Thank you, sir. Now we will move on to our question and answer session. Sir, should we take some questions?
There is no problem.
Yeah. The first question is from Ravindra Agarwal. As I could understand from the Income Tax Act 2025, now even the accumulation up to 15% of the gross receipt has to be kept in the specified mode. This sounds impractical. Please clarify.
This provision is there. Now, we cannot say that this is practically difficult. We have to comply with. This provision was not there in the earlier regime. 15% you were at liberty to invest as per your choice. Section 13 did not have this type of restriction. But I was also very much surprised. Friend, I would like to advise you one thing more. When these rules 2026 were introduced, draft form, I wrote not less than 30 to 35 mails to CBDT whatever grievances we have, we must write to CBDT that this is our grievance. Address of CBDT, you all are having chairman at the rate of cbdt.nic.in. Very simple address of chairman CBDT that you can get anytime. But if we are having such genuine difficulties, I would recommend you to go to that revocability clause. You write to CBDT that this is a very serious issue we are going to face, and we will be facing a lot of litigation where you too will be a party to that, and we will go away from our main object. So, friends, if there are difficulties, we have got the solutions either at our level or at the government level.
Second question is from Kapil Agarwal. Educational society turnover less than 5 crores having 12A and ATG registration valid for AY 2027-28. When to file for renewal, which form to be filed and which clause to be mentioned for registration.
105 you will have to go in for that. And now in section 332, there are number of clauses under table 332. Probably that will be row 4 of 332. Just check up 332, either 4 or 5.
Yes, sir.
And that one more interesting part. Application is required to be made 6 months before the expiry of your period. And now there is no question of assessment year and previous year. Now we have only tax year. So if your tax year is 26, 27, means your approval is ending on 31st March 27, then you will have to apply before 1st October 26. Friend, I will narrate you my experience. In my case, all the application I filed on 1st April 2025 under the old regime. I am talking about old regime where application was 1st April 25 to 31st March 26. I applied in 1st April 25 and I got all my applications settled before 31st December 2025 because now the time limit is 6 months from end of the quarter. Now this is very notorious terminology they are using from the end of the month and from end of the quarter. Even if you apply April, your April is vested, May is vested, June is vested, because they say from the end of quarter, from 6 months after the end of the quarter. See, these all music you have to face, but you have to abide by the provisions.
Yes, sir. Third question is from CA Trivedi. Return filed under AOP or trust registered under section 12AA. What is beneficial? Also, fund not utilized, that is 15% cap for trust registered under section 12AA should be reflected in Form 10, that is to be filled by the trustee.
If you are registered under section 12AB, you have no choice of AOP form 5. It is mandatory to follow form ITR 7 only. And if you don't have 12A, you have the option nothing other than ITR 5. That is AOP without registration, a regular part 4 of business income. If you have not applied your income, you have the option of accumulation under uh, form 10 or 9A under the old regime, but now old regime is not there. So you will have to go in for form number 108 and 109. You cannot now, friend, I have repeatedly told you this is purely trapping. Oh, so you have no choice. You have to strictly comply with. Otherwise, face the music of 333 accredited income. They will not only reject your application, they will cancel your earlier registration, they will cancel your earlier approval. So read the conditions very carefully. Not only the application is rejected, they add one more line at the end. We will cancel your registration, we will cancel your approval. And cancellation of registration and approval mean that they will take you to accredited income, they will value your property at market rate and charge to tax at the rate of 34 maximum marginal rate. So now you have to be very vigilant, extremely vigilant.
Okay, sir. The fourth question is, want to change the address of charitable trust from Kolkata to Delhi. How? Any permission required?
This is a technical part. This is so far as your regulator is concerned. So far as your books of accounts are concerned, you have to just intimate to your jurisdictional level that you have shifted your office from this place to this place. You change the address on the portal, and then your issue will be solved. This is in the context of keeping the books of accounts at the registered office, because the act says that you have to keep the books of accounts at the registered office. If you change the registered office from Delhi to Calcutta, Calcutta to Delhi, your jurisdictional level will change, and you will have to intimate your jurisdictional level also, apart from changing your details on the portal.
Okay. Next question. Educational institution having annual receipt around 3 crores exclusively for the education purpose. Is this registered under any of the provision of the Act 2025? It's registration.
Question is not very clear.
No, sir, actually. We will move to the next question. Next question is, existing institute registered under local state act and activities are also started before 2021. However, 12A, 12AA, 12AB not applied under IT Act till the date. What is better option to register under 12AB under the IT Act 1961 along with the application of condone delay, or apply directly under the new Act 2025 for current tax year only?
This is a very mixed question, but I would recommend you to file under the new act only, because if you go in for delay condonation, they will see whether the justifiable reason is there. And I don't think that for such a period of 5-year delay, there will be any satisfactory reason to explain the delay. The only precaution you have to take is that you have to file the return in form ITR 5. Even if it is under ITR 5, you have to see to that the return is filed, and if the tax is payable, you have paid the tax. My sincere suggestion will be for apply newly under 332 with form number 105, no 104.
For the Gaushala Trust, if the trustees have taken land on rent and started some activities for welfare of cows, then which form to be filed, 104 or 105?
The mixed question. If your activities are already commenced, naturally 105. Activities commenced means 104 are closed.
Okay.
And
The
rental property or self-occupied property doesn't make any difference.
next question is, an NGO got its registration under 12A cancelled in 2013. In 2026, it want to apply for first registration under new act. Which form is to apply first?
105 only, but you produce that old registration certificate along with that. 104 doors are now closed.
Next question. During the financial year 25-26, the trust received donation. The trust has not spent a single rupee on its object during 25-26. Under such situation, can we say that the trust has commenced its activity only by receiving the donation?
Mere receipt of donation is not a part of commencement of activity. You have to see the application itself. I will have to go through the exact facts of the case, but mere collection of the funds may not be enough for in this case. You can take a stand that I have already started my activity and going for accumulation, form number 109. You have to give some proof. 109 will say that you cannot apply. So this will be of help to you.
Yes.
109 is meant for that purpose only. Accumulation, not application. And frankly speaking, there will be definitely some expenses incurred in the year 25-26. I will narrate one example. What about the audit fees for the year 25-26? That is bound to be there. So that will be very much expenditure on the object of the trust only. That expenditure is to be treated as expenditure on the object of trust only. Because that is for the purpose of application of income. As I told you, you must twist the facts very properly. So if there is a provision for professional fees, and there must be some meetings held of the trustees, they must have taken some decision. So accumulation in form number 109 is very simple, no problem. You have to see that investment is as per section 350.
Next question. School run by charitable trust registered under IT Act for AY 25-26 total receipts 40 lakh, applied 37 lakhs, net surplus 3 lakh, which is within the 15% limit. Now CPC tax 3 lakh and tax liability created. Is this in line with the provision?
No, if your registration is under 12 AB under the old act, there is no question of taxing 3 lakhs. Because on, you see, in this case, in fact, this was the point I wanted to talk about. Because of shortage of time, I could not speak on accumulation. In this case, your income is 40 lakhs gross receipt before application. So you are straightway eligible for 6 lakhs accumulation. So you are required to spend only 34 lakhs. You have spent 37 lakhs. So you have spent more than what you were required to spend. There must be some data entry error so far as the form is concerned. Otherwise, in the light of the fact, your income 40, application 37, you have crossed the limit of 85%. There should be no total income which is liable to tax. There must be some, or it is quite possible that form 10B or 10BB, in this case 10B is applicable, is delayed. I will have to find out the reason because of which this tax demand has arisen. Otherwise, in the light of the discussion we have made, 40 lakhs income, 34 lakhs is only required to be applied, 37 lakhs is applied. My income is below 3 lakh, my income is nil. So no question of tax liability. You have to find out whether 10B is filed, whether it is in time, whether there is any data entry error. But in the light of these facts, there should be no tax liability. Yes. Even you can apply for 154 rectification if the fact is applicable as per the discussion I have made.
The next question is, during the financial year 25-26, a solely educational trust have annual receipt below 5 crores. The trust is not registered under 12A. While filing ITR 7, can I claim the exemption under section 1023C without applying for 12A exemption?
This is the last year so far as 1023C is concerned. 25-26, this will be the last year. FY 26, 25-26, yes. 1023C, all the benefits of 61 Act are available. Return now we will file will be for the under the Income Tax Act 1961, because 61 Act is in force up to March 26. So return of FY 25-26, previous year 25-26 will definitely be furnished after taking into account 1023C. If your receipts are below 5 crore, in my opinion, there should be no problem. However, other facts I will have to see.
Okay, sir. The last question. In Form 10BB, Clause 23, amount disallowable under 13 provision to Clause 23C of Section 10 or Explanation 3 to Subsection 1 of Section 11, read with Subclause IA of Clause A of Section 40, which amount is to be written off in above clause, whether it should be 30% disallowed amount or it should be 100% of payment amount on which TDS not deducted.
Section is very clear as per the provisions contained in section 40A. So 40A talks about 30% only. So here disallowance should be 30% only. In some softwares, they are disallowing 100%, but I differ on that treatment. In my opinion, strictly we should go as per 40A1A, 30% to be disallowed.
Okay, sir. Last, the sir, while we file 12A application, portal shows a message that if trust activity is already started, you directly file application form for permanent registration. In light of this message, in our one case, we have filed application directly for permanent registration, but the same was rejected by the registration authority stating that you do not have provisional registration. But why portal shows such message? Please guide.
Have you given the information activities have already commenced? You see, the one more issue with Form 10AB is that selecting of the proper clause, because 10AB has got number of clauses, and in my opinion 6B need to be selected in this case. I will have to see which clause was selected. If the wrong clause is selected, that might have created a problem. Selection of the proper clause is extremely important. I repeatedly use the term this is trapping. Henceforth, the data entry is extremely important. As long now that 40 lakhs case, 40 lakhs, 34 lakhs, so there remains no income to be taxed in the hands of the taxpayer. But still the demand is raised. So like that case, there must be some issue in this case with regard to the option that is exercised.
Yes, sir. Should we conclude now with your permission?
Yes, no problem.
Yeah. Thank you, sir. I would like to express our gratitude to our esteemed speaker, C. Suresh Mehta, sir, for valuable insight and addressing the participants' queries so effectively. I also thank our chairman, Chitre sir, vice chairman, Pankaj Shah sir, and all the participants present and active participation. With this, we conclude the today's seminar. We will start our next seminar within 5 minutes. The topic is taxation and walkthrough in SOPs. The speaker is C.A. Sachin Maniar, former chairman, Pune branch of WRC of ICF.
बर आता हे करा आता हे कुठे करायचं ते? कुठे
सर हे बंद करा
हे?
नाही ते खाली खाली एक फुल्ली आली सर
कुठे
एकच मिनिट
फुली कुठे
सर इथे आहे.
हा लीव इथे आहे अगं
हा खाली
हा लीव